Hello and welcome back to the Legal Trifecta, the podcast where you can gain the legal insights from a senior attorney, a junior rising lawyer, and an ambitious paralegal. Without further ado, let's get right into the episode. How are y'all doing?
Good. How are you?
I'm doing really good. Have a lot of energy, so I'm excited. How about you, Sandy?
I'm doing great. It's Friday afternoon, and I'm happy to be near the end of the week.
Yes, totally agree. And so this episode, we really want to be talking about leap day, leap years. And this was an idea brought by Angela, from my understanding.
Actually, yeah.
Sandy, you wanted to talk about this. And why did you want to talk about it?
Because it only comes around once every 4 years. So this seemed like it's coming around and it's time to talk about it.
Yeah.
Because people think it's only one additional day in a year. But sure enough, over the decades, lawyers have figured out how to create legal issues over the addition of a single day into February.
Yeah, I had no idea that there would even be like legal matters to address because of a leap year. So let's get into that. So Angela, do you want to lead us into that?
Yeah, so it can definitely cause some implications. So for example, if there's a cause of action that accrues on leap day, February 29th, and say...
What's a cause of action?
A cause of action is a significant event that gives rise to a lawsuit. So for example, in a motor vehicle accident case, it's the date of the accident.
Okay, gotcha.
The date of the collision. So say that a cause of action accrues on February 29th, and there's a 2-year statute of limitations. Then that presents a question. Does that lawsuit have to be filed by February 28th, or can it be filed by March 1st? Texas doesn't answer that question directly, but at least 2 other states have. Indiana, in a case called McElwee v. Fish. In that case, there was a cause of action accrued on February 29th, and the plaintiff filed suit at the last possible minute.
As lawyers love to do. Deadline means we don't do it until the deadline. Then we do it on the deadline and don't miss the deadline.
Right. Yes. So they definitely were pushing the envelope, and they filed on March 1st, specifically 2018. So the court had to decide, was it filed within the 2-year governing statute of limitations? And they had to decide when the deadline for the statute of limitation was. And the 2 choices, obviously, was between February 28th or March 1st. And in that case, the court decided that it had to be filed by February 28th. So they did not meet the statute of limitations deadline, and the case was dismissed. So it can create some serious implications. The case was thrown out. So you have to be very careful and, better safe than sorry, and get that lawsuit on file by February 28th or earlier.
Don't wait till the last day,
don't wait till the last minute.
discussion.
So I'm guessing, Sandy, you've never had to deal with that? Seems like you're not waiting till the last minute, so.
No, we work real hard on not waiting to the last minute to file a lawsuit.
Yes.
Because Texas is different from many states. If you are in the federal system, generally for what we call limitations, which is you have a limited amount of time in which to bring most lawsuits.
Right.
Now that, depending on what your claim is, that can be as short as a year. It can be as long as almost forever. Like 25 years is the longest statutory one in Texas. The 2 big ones that we worry about all the time are the 2-year statute of limitations, which applies to most what we call torts, personal injury cases. Somebody gets hurt, whether in their body, their person, their property. They have 2 years from when that happens to bring the suit. Then we've got contract claims, which is you have 4 years from the breach of contract. So that's typically a basic contract. It can be a promissory note to repay somebody. It's any form of debt under the Texas statutes. They talk about that. So what we try to do is not to file near the end of that period in Texas,
Right.
because Texas is a state that, in order to perfect the filing of the lawsuit to show that you are within the time permitted, is number one is it must be filed within that time period, and two is you must either complete service, in other words, delivering a copy of the citation from the court, the state of Texas greetings, you have been sued, to the defendant along with a copy of the lawsuit. You have to serve them either within the statute of limitations before that 2 years or 4 years runs. And if not that, then if you file right near the end, you have to exercise due diligence in order to serve it. So you can file on the last day in Texas as long as you show that you've used due diligence to actually serve the citation on the defendant.
What do you mean by due diligence? Just trying.
That's a good question. So,
is it vague on purpose?
yeah, and it's mostly defined by what the courts have said was not due diligence. Due diligence is I filed my lawsuit, I go to the clerk's office, I say, I need to get this citation issued. I need to get it pretty quickly. Once I have the citation, then I've got to get it over to a process server. And then I've got to get the process server to go out and actually deliver a copy to the defendant. And I need to do all of this reasonably quickly. Filing the lawsuit, waiting around for 2 months, and then asking the clerk to issue the citation. Because in Texas state court, they don't do it automatically. You have to ask them to issue the citation. Wait around for 2 months, and your case is probably dead because that's not exercising due diligence. Getting the citation from the clerk and getting it in the office, putting it on the stack of papers on your desk and say, I'll get to it, and waiting for 5 or 6 weeks to get to it, that start verging on not really being due diligence.
Okay.
Taking that and getting it to the process server and then forgetting about it until 4 months later, we're like, hey, didn't that get served? And you call up the process server and you're like, hey, whatever happened? Did you serve them? And you discover the process server has not served them. That may or may not be exercise of due diligence. If your process server is, I went out there every day and knocked on the door and there was nobody there, and here's the affidavit, and I tried 50 different times to serve this, and I tried their home, and I tried their office, and I tried the other places that they are known to hang out, that could probably be due diligence.
Yeah, looking more like due diligence.
Yeah.
If it's I did a drive-by the first day I got it in the evening at their house, all the lights were out, so I assumed nobody was there, and then I forgot about it, that's probably not due diligence.
Okay, excellent.
And in Texas, the burden is on the plaintiff. So
That was my next question.
Yeah, once the defendant says, hey, I didn't get served within the applicable limitations period, it is the plaintiff's burden to show that they did exercise due diligence. It's not the defendant's burden to show the plaintiff failed to exercise due diligence. So you don't want to have to take on that extra burden in the lawsuit of having one more thing that you need to prove. Lawsuits are difficult enough already without adding on to the issues that you have to convince a trier of fact that you exercise due diligence in actually serving the lawsuit.
So I'm guessing that's when like the quality of your attorney matters the most.
The quality of the attorney, but also the quality of the office processes that are in place. It doesn't, it's a very low threshold for an attorney to timely prepare and file the petition, to request citation, to initiate service. A lot of it is the follow-up processes that you have in place. Attorneys get very busy, staff gets very busy. So you file a lawsuit and it might slip away. It doesn't show up on the daily agenda for a few days. So you really need to have the procedures in place to assure that there's timely follow-up on each of the steps. One is that you get it timely filed, because otherwise you're dead. Two is to make sure that you get the citation requested and issued, because You have to put in the request. You have to pay the fee in Texas to get the citation issued.
Is that expensive?
It's $8.
Oh, nice.
Not bad.
In district court, it's not bad. And when you make that request, you need to follow up on it. Every so often, you'll run across a clerk's office where the request may get lost. They may not act on it in the e-filing notes, and you need to follow up. It's not enough to wake up 3 months later and say, well, we were diligent and it was all on the clerk. No, it's your burden to follow up to make sure the citation gets issued.
That's where there's room for error.
Yes.
Yeah.
Interesting.
Yeah.
So is this like a common issue?
It's more common than you might think because for whatever reason, defendants like to raise this defense whenever they get close because it kills your case.
Yeah.
If you
It's like
miss,
the easy way out.
Yeah, if you miss the limitations period, you're dead. There's mostly no reviving it. Now, yeah, there are excuses that are permitted in Texas on tolling limitations, on when the limitations period accrues. But once you're on the clock, you need to get it done in order to protect your client's rights, which is why February 29 is one of those peculiar problems, because it's not intuitively obvious that if an accident happens on February 29th, then you've got 2 years. Why doesn't that go to March 1 and why does it stop on February 28? So, but one of the reasons I was interested in this topic is because I ran across a term that I had never seen before, which is bisextile.
Oh,
Yeah. Meaning leap year.
which is the more formal, almost Latin name for leap day.
okay.
Yeah, the bisextile.
You learn something new every day.
Bisextile. It's Bisextile. And I'd never known that before. I ran across that and I thought that was interesting. So what other issues do we get out of this leap day?
One fun one is what if you're a leap day baby?
Right.
And you're born on February 29th. It is your 21st birthday and you want to celebrate. So when can you start celebrating? Can you start celebrating February 28th? Or do you have to wait until March 1st? And at least in Texas, you do not officially turn 21 until until after 11:59 p.m. February 28th. So March 1st.
Oh, interesting.
Yeah.
So that's fun.
Yeah.
Good to know for all the viewers that are turning 21. I just did, so it's exciting. But yeah, what else? Tell me more about leap year.
Yeah, well, something that Texas has spoken about is the meaning of like month. And that means it's a calendar month.
Okay.
So, for example, January, it's going to that's going to include all 31 days, and February, depending on the year, that might mean 28 or 29 days, and a year. Like in a contract, for example, that'll mean a calendar year. So whether or not that's a leap year is what that means.
Okay, interesting. Interesting.
So even if a month has 28 days, 29 days, 30 days, or 31 days, in Texas, it's counted as 1 month. It's not tied to the number of days in that particular month.
Exactly.
Yeah. It shows up elsewhere, which is in accounting and in many contracts that provide for the accrual of interest. Their method of sort of accounting for leap years is often ignore the leap day. So you will often see contracts providing for interest to accrue on the basis of a 365-day year. So when you're looking at, you have a loan and you're accruing interest on a daily basis, then you get to a leap year and it's like, okay, so am I accruing 366 days of interest or am I accruing something less than that? And to simplify calculations, the loan documents you see in many transactions say that interest will be calculated on the basis of a 365-day year. So their approach over in much of the financial industry is never mind that leap day. You can have the money for free that day. So,
okay. That's interesting and funny.
I don't know why leap day is appended to February, because
That's true.
you have 12 months in the year. You could make January longer, February longer, March longer.
Yeah.
And for whatever reason, it's appended to February. It may be because February starts off as the run to the litter. It's only got 28 days. So give it a 29th. A month like August already got 31 days. Doesn't really need a 32nd.
Yeah.
So but it's interesting that you wind up picking February for that.
Well, do you know what calendar we base this off of?
The calendar that we currently use now.
Because different societies had different calendars, and we decided a certain one with that amount of days.
Yeah, we in the US we use what's known as the Julian calendar, which divides the year into 12 months, and then the months are composed of more or less weeks, and then you have 7 days to the week, and that largely replaced what was known as the Gregorian calendar, which was in use for a long time.
Amazing.
But you're right. Different cultures, different religions, different countries have different calendar approaches. It's what the Chinese New Year does not fall on December 31st.
Right.
So and the calendar that we use uses 12 months of varying lengths, and for 3 out of the 4 years is 365 days. The reason for adding the leap day is if you only had 365 days, that does not exactly match the precession of the sun, the earth around the sun. I almost said the sun around the earth. of the earth going around the sun. And if you strung together a whole series of 365-day years, little by little, when winter comes, when spring comes, when summer comes, would start to shift on the calendar. And so by adding an extra day each of those 4 years, you keep pretty much, you keep winter in that whole December, January, February time period. You keep the height of summer, June, July, and August. But those would, over the course of years in the lifetime, that would gradually creep all the way around the calendar, which may or may not be good, but that's the reason for leap years. And then because you're tweaking the calendar, the Earth's precession around the sun is not quite 365 days. It's off by about a quarter of a day. And so every 4 years you tack on that day, and that mostly makes up for it. But it's not quite exactly 1 quarter. So once every so often, and I honestly don't know this one, but it's at least once every 100 years, they make one final adjustment, which is that even though it is a year that would normally be a leap year, they do not insert a leap day. So that keeps everything nice and flowing. Yeah.
I have a random question.
Sure.
And maybe this is a dumb question, but is there any preferable time to file a lawsuit, like in the seasons or at a particular month that is better or convenient?
The filing a lawsuit is after you have, there are different factors that go into that. sometimes you want to file a lawsuit right away because you're concerned that evidence is going to disappear.
Like, what's an example of that?
If a factory blows up and suddenly you've got all the restoration screws out there, or you've got fire investigators out there, you've got the chemical safety board out there, you have everybody under the sun tromping around through the scene, gathering up what they think is evidence, taking pictures and messing things up. You want to get your people out there as quickly as you can. You don't want, if you're bringing an auto products case and something failed in the automobile when it shouldn't have, you don't want your most important piece of evidence to be towed away and crushed in an automobile crusher to disappear, because that also really takes away your lawsuit. If it's an auto products case and you don't have the product, the auto that you say was defective.
Makes sense.
So sometimes you need to get down to the courthouse right away to preserve evidence. Sometimes you need to get down there to get your people onto the scene. Other times, something happens and you really don't have an idea of who do I need to sue and what do I need to sue them for. So you have to do some investigation, a reasonable investigation, to have a factual basis for bringing a claim. So that can be looking into what happened. That can be looking into where do these people come from? Who were they? What were they doing? Who were they working for?
Talking to witnesses.
Yeah, talking to witnesses. It can be all sorts of investigation that you want to do before you actually file the lawsuit. So that's sometimes a reason for waiting. The other reason you run into can be that if you do a lot of personal injury work, and we do a fair amount of that, you like to have your client get better to see how their medical progress is going to be. If your client's going to be in the hospital for 2 months, and then in a rehab facility for another 2 months, and then trying to get back into the workforce for another 2 months, you want to let that process substantially move forward before you file the lawsuit in many cases. Because if you're looking at disposition of a case by settlement or by judgment, you want to have the best possible fix on what is the client's condition going to be at the end, and what's permanent, what's temporary, what are the limitations they're going to have. Sometimes right away they get blinded, they lose a limb, they're permanently disfigured from burns. You've got a pretty good fix on what's happening there. Right. But other times it's a long struggle for the client to recover anything resembling their pre-accident lifestyle. Yeah. So it's very much sort of like when the case is ready, it needs to be filed. You don't just get it all ready and put it on the shelf. You say, I know who to sue and what to sue them for. Once you have that, then you've got the client to the point where you've got a pretty good arm around what the damages are, then you go ahead and sue.
And how do you prepare a client knowing that they are in pain and they're struggling with whatever injury that they have? How do you prepare them for basically a really long legal process, right? There's a lot of deadlines that I think clients, they want justice now and they want money now. So how do you prepare clients for that?
I think just letting them know what the process may look like, worst case scenario. Sometimes these lawsuits will drag on for years. Right. And unfortunately, if they're, receiving medical treatment, they're probably going to still need to continue that treatment while the lawsuit is going on. But just kind of making sure that they're aware that this is not going to be something quick. It hardly happens that way. Sometimes the case settles and it doesn't need to go to trial, but oftentimes these things can last years. So it's just a matter of letting them know.
Yeah, that's always helpful to give them as much information as possible. Yeah. What about you, Sandy? Do you have anything to add on to that?
on how to prepare clients for the process and how long. You just have
It's a constant process.
You have to keep them informed about what's going on with their case, because that communication is useful for the clients to understand the process, and it's useful because the clients realize that something is happening with their case.
Right.
I think clients get the most frustrated when they go hire a lawyer goes out and maybe perfectly diligent, files a lawsuit, engages in discovery, does all these things, but the client never hears from them. And so the client's sitting around wondering, I hired this lawyer 8 months ago. What is she doing, or what is he doing? And
that's where I come in, 30-day follow-ups.
Yeah. and they just get frustrated over what's the state of my case. Now, we've made pretty good progress over time in getting lawyers to talk to clients and keep them updated on cases. Technology helps us on that by quite a bit,
right?
Because it's much easier to send documents to clients. It's much easier to send updates to clients. And we use a process of trying to reach out to a pretty good number of our clients on at least a 30-day basis or a monthly basis. I should be careful. There's a difference between those two. On a monthly basis.
Right.
To see how they're doing, to answer any questions, and see how the process is coming along. What is difficult for clients is trial settings and the lack of control that we have over the courts.
Right.
We can file a lawsuit, we can get a trial setting, but a trial setting will be on a docket with 25, 30, 35, 40 other cases. And then it's a matter of, is the judge actually going to take this case to trial on this trial docket? And it's not unusual to be set on the trial docket 2 or 3 times before your case actually goes to trial. And it's sort of a hurry up and wait process.
Yeah.
It's frustrating to clients. It's frustrating to the lawyers who want to move the case and get things done.
Well, I think an aspect of legal work that isn't talked about enough is the emotional toll that clients will express to you, right? So I think a lot of my job, especially in the beginning, because I do hybrid, I'm a student, but when I was doing like intakes or something, or they're asking for these updates, or they're feeling very frustrated because even after updates, they're like, this isn't fast enough. You have to sit there and you have to empathize for them and with them. And so, yeah.
And clients like to have closure on events in their lifetime.
Yes.
Particularly if it's been something serious, and they don't want to go through the stress of reliving the experience and recounting over and over what happened. And when you have a trial setting, you call the client up and say, we're on the docket. We may be going 2 weeks from today. We may not. That, for many clients, triggers a process where they are again reliving what happened to them.
Right.
For most of our clients, what happened to them is not in any way pleasant. And so they are stressed out by having to relive this. Then typically, if you don't go, they have a moment of relief. They're like, great, it doesn't go. I can put this out of my mind again.
Right.
But then when you call them up 4 months later and say, we're back on the trial docket, then you once again trigger a reliving of the bad experience.
You have to do it all over again.
Right.
That makes a lot of sense.
They want to get their compensation for their injuries. They want to get the case over with. And it's as much as I like the clients, I tell them near the end of the case that it was great representing you. I'm glad we got a result that you're satisfied with. But I certainly hope you don't need our services again in the future.
Definitely, definitely. Yeah.
So what have you found in that regard with talking to clients about their frustrations over the timing of the system?
Just listening to all of their issues. letting them know what we're doing, how we're best able to help them. Like you mentioned, just keeping them updated so that they don't assume the worst, that nothing is happening with their case.
Right.
The more information they have about the process and the different options available to them and the one that we're pursuing and why, I feel like that gives them comfort, letting them know that we're doing that hard work of navigating the complex legal system.
Yes.
So that they don't have to worry about that, so that they kind of feel like that we're helping them in that way, just navigating that complex system.
Absolutely. Yeah. I know I've had clients multiple times. This is what I didn't know, that you would have people, and maybe logically it does make sense, crying in your conference rooms or your offices, expressing all this and struggling to finish filling out their intake paperwork or describing how their family is financially burdened by it because they're the breadwinners and stuff. And for me, I mean, do you guys face an emotional toll? Because I know when I first started, that was a little bit of a shock for me. I was like, oh my goodness, separate those things. There's a way to be professional about it. But I would be lying if I didn't say that those stories didn't make me a little upset.
It is difficult with clients to retain the detachment that you need to properly advise them, to be able to stand back and say, these are the facts. This is what we know we can prove. This is what we think we can prove. This is what the other side is going to do, and give them your best professional advice as to how to move forward.
Right.
There are clients who are placed, sort of knocked off the road of life. I don't know if you ever played that game of life game where you have the board and you got the little car and you turn the spinner and everything moves forward. And many lawsuits are kind of, you're going down the road of life and then something just hits you from the side and throws you into this whole swamp of damages, which is, you're not moving forward with your life.
Right.
And for many people, it's financially devastating. They've been hard workers their whole lives. They've furnished a house and food, shelter, transportation for their families. And then suddenly something happens. They can't work. The money's not coming in. The lawyer keeps telling them, your lawsuit's progressing, but they're not
seeing any of it.
Yeah. It's like, where's my money? So and you do get clients. It is such a trying emotional toll for clients who, particularly the ones that run out of money.
Right.
And then others where we represent people who have sustained catastrophic injuries. For them, it's not just a question of how long is it going to take for me to put my life back together or to put my loved one's life back together. It's much more this realization that it is never going to be put back together, that these limitations that I now have or that my spouse has are permanent. They are going to be with us always.
Right.
And there's an enormous psychological adjustment for clients that have disabling permanent injury. Very much all the stages they talk about with death, which is the sort of, the
denial.
Yes.
Anger.
Yes.
Bargaining or something.
Yes.
Trying to. Yeah.
Yes. Denial, anger, bargaining, acceptance. I'm not certain I can remember like all the 10 steps of accepting death.
Well, because it's also not linear. So sometimes you might have a client that comes in initially very frustrated, very emotional. You see them gradually get better, then all of a sudden it's back to where we started.
Yeah.
So it's definitely a journey. Yeah. In law school, do they teach you about like EQ, like emotional intelligence?
Not at all, actually.
Really?
Yeah, that's a good idea, though.
Yeah, because you're working with people. You know, I think Sandy and I have had this conversation where it's like they don't teach you like how to run the business or anything, but I didn't know if they like taught you how to like, you know, handle with clients.
Yeah, I think that's something that anyone can benefit from. Yeah.
Yeah, for sure.
Yeah, they pretty much drum that out of you in law school. It's not like what emotionally feels right, the right outcome in this case. Like, no, this is the law. You need to think like a lawyer. You need to think about how these words go together and what the practical results are.
Right.
I don't recall any point of course, I went to law school a long time ago, but I don't recall at any point in law school there being any discussion of anything to do with what seems emotionally correct or an emotionally good outcome for a case.
Are morals talked about, like ethics? I mean, I'm sure ethics are talked about, right?
I think there's an ethics course.
Oh, okay.
Yeah, and we do in legal education talk about morals, but they're spoken of in a way that is to make clear to the student that moral obligations, for example, are not the same as legal obligations. So while you may come across an injured person as you're out for your evening walk and feel a moral obligation to assist that person, for example, in whether it's crossing the street, getting up from a fall, summoning medical assistance for them, you have no legal obligation to do that. And so in that sense, we talk about moral obligations versus legal obligations in law school, just to make it very clear to the student that we're not here studying morality. We're here studying the law. Has very little to do with morals, just the law.
Yeah. I think if anything, emotion was removed from cases, you know, and just trying to figure out what the rule of law was or holdings are in certain cases.
Right.
Yeah, emotion was removed.
That's so interesting. That's going to be my learning curve. As you guys know, I'm a little sensitive. Yeah, no, that's funny.
It is, because you read cases in law school and you're like, well, that doesn't sound right. That doesn't sound like it should be the right outcome.
Right.
And a lot of law school is, well, why did the court reach that outcome? Why did the court reach that outcome on these facts? And then you get the great revelation that the next state over, the other state's Supreme Court, came to the complete opposite result. So, because we live in a federalist society where we've got 50 states and the federal government. Which reminds me, back on limitations, one point that I did mean to mention was that the federal system's method of measuring limitations is different from the viewpoint of if you've got a federal claim and you're filing in federal court and you have a specific statute of limitations. It is the filing of the complaint within the limitations period that suffices to make the case timely. You still have to get the summons issued, which is the federal equivalent of the Texas state citation, and you still need to get it served, and you still need to exercise diligence in doing that. But it is not necessary in perfecting the filing of the suit to get that accomplished within the limitations period. It's the filing of the complaint itself that initiates the case. So there's a little difference there between being in the federal court system and being in the state court system.
Important differences.
Yeah.
Well, that was a great tie back, great little connection. Yeah. Do you all want to summarize the points that we discussed today?
Well, there were so many points that we discussed.
we did
kind of bounce all over the place.
I think the important part is be aware that leap days could have some legal implications, that mostly the courts have worked out ways to address the issues that arise from having an extra day every 4 years. And counting is important. And we count all the time as lawyers. It is a very deadline-driven practice.
Yeah, what do you say? Live and die by the calendar. If something doesn't go on the calendar, it could very well get missed. Right? So, like, that's very important to make sure to calendar everything.
You know how many times I count? Because, like, I will calendar a lot of dates. I count it 4 times, right? The first time it doesn't take very long. And then maybe if I get, I'm like, wait, that's one off. I'm completely wrong. And it's just like, that's very time consuming. But I try always to get it right.
Important work.
Yes.
Yeah, because Alejandra does most of our calendaring on scheduling orders and on the level 1 and level 2 deadline cases that don't have independent scheduling orders. So, which is a repository of trust in her, because if there's one thing that you really should not get wrong in running the law firm are the calendar deadlines.
No pressure.
Yes, no pressure.
Yeah.
Not tedious at all. No, but I think one thing that you have to have in common, and this was one of the first discussions I remember having with you, is that it is very tedious. You know what I mean? And I remember you giving me the tip of like reading backwards or something to not make sure you like make mistakes. Yeah.
Yeah, and some of these orders that the courts enter in counting have these nested deadlines, where it's here's a deadline, but 15 days before that deadline, you have to do something else. And then within 7 days after that deadline, you have to do something else. And that's the way that it's written. And you have to figure out what are these dates and
like reverse engineer dates.
Yes. Like, why am I doing math? Like, I thought I was
And there are different styles of writing scheduling orders. There are scheduling orders where some judges like, where they say, I'll put in a trial date. And then I've got language that describes what the other deadlines are. And they are either keyed off this trial date, or they are keyed off of the other deadlines as they interact with each other. And sometimes they're keyed off of when was the lawsuit filed. So you've got that style of scheduling order. The other style of scheduling order is we're going to try to dispense with all of this counting, and we're just going to put the dates in. So you'll see a scheduling order, and the left side of the page is just date, 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 date. On the right side is this must be done, this must be done, this must be done, this must be done. Those are nice and clear.
I'm sure you love those.
I prefer those. I'm not going to lie.
You've seen both styles, right?
Yes. I've seen them all, I think. Well, probably not all. I'm sure there's always going to be a surprise. But yeah, I've definitely seen versions. And I think that one where you have to go backwards, least favorite.
Yeah. Yeah. It and sometimes you run across things in scheduling orders that you have to do detective work almost.
Yeah.
I just had one this week. We're coming up for a federal trial. And so we have to, when you read the scheduling order, it has a plain vanilla provision that there's a deadline for filing the final pretrial report. Now, that to the lawyer's ear sounds odd, because in federal court, you're almost always talking about a final pretrial order as opposed to a final pretrial report. So there's a little variance in terminology. But then the scheduling order went on to say, using the form set forth in Appendix 4 to the local civil rules. And I thought, great. So
scavenger hunt.
you go over to the local civil rules, and they're right there on the court's website. And you go to Appendix 4. So did that. There's no Appendix 4. And there's no suggested form in that district for pretrial order. There's a group of judges, and you go through and you click on each of these judges, and it's got their own courtroom procedures, and they've got their own particular formats as to what they like or they don't like in a final pretrial order. So I'm thinking, okay, this is great. I'll just find Judge X in my case. And I run down the list. I'm like, Judge X is not here. Now that can't be right. Go back to the top, read it again. No Judge X. Go back a third time. Because I'm thinking, this is Judge X. And the case is in this district. And it's right there. And I go through and I'm like, he's not there. So I'm thinking, wait, is Judge X so new that he's not on the website? So Google Judge X to make sure. But he's been on the bench for a while. And I'm staring at this and I'm like, And then I realize Judge X is actually was nominated and confirmed not in the district where this case is pending, but in the next district over in the state. And I'm like, oh, you don't suppose. So instead of looking at the Northern District local rules, I thought, well, what if I went over to from whence he comes, Judge X, and I'll look at the Western District rules. And you don't suppose that if I go look at the Western District civil rules, that there would be an Appendix 4. And there's the sample pretrial order that he ordered in the case that was pending in the other district.
Oh my goodness.
So then I pull that up and I'm like, and preparing the final, and it's called the final pretrial report. So it's got the right language, the right style on it. Then you have to, because final pretrial orders in federal court are joint productions, and they have to be produced jointly by all parties to the lawsuit. I then took all of this, like I have found the golden treasure, not where we thought it would be found, but we found the Appendix 4 form. And then I had to write an email to the other side saying, this is what I think the judge is referring to when he talks in the scheduling order about the format for the final pretrial report. That's what we plan to use in putting together our part of it. If you think there's some other form that he means, let us know so we can get it worked out. And I sent that off. And later that day, I got a response from the other side. I don't think it thought about these issues and said, that's fine. Let's use that form. So.
Oh, nice. It all worked out.
It all worked out, but it was
ridiculously hard.
Not ridiculously hard. It's just that sort of chase that you go on to find things.
Harder than it needed to be.
Yes.
Yeah, and federal court is a fascinating place to practice, but it has become one of the great unifying things about the federal courts was the creation of the Federal Rules of Civil Procedure. Federal courts before that occurred now is 85, 90 years ago. They had the procedure that you would use in federal court in a particular state mirrored the procedure that occurred in state court. So if you went from federal court in state A to federal court in state B to federal court in state C, they would all have different procedures based on the procedures in effect in the state courts in those states. And that actually has some merit to it. You don't have to learn, if you're a lawyer in that state, a whole new method of procedure with a whole different set of rules. And the rules can be very, very different between the two. But Congress, passed the Rules Enabling Act in the 30s, if I remember right, enabling the Supreme Court to create these uniform rules of civil procedure. And so we got the federal rules, which were uniform everywhere. And that was an enormous development. And for the longest time, things stayed pretty uniform. Now, there's sort of a balkanization of sorts. In each district, you've got a local set of civil rules, which augment, probably the best word to use, augment federal rules of civil procedure. And they, from district to district, have their own sort of idiosyncrasies about how things are done. How do you put together a motion? If it's over a certain length, does it have to have a table of contents? Does it have to have a table of authorities? If you're going to file a motion with the court, do you have to confer with the other side about what you're asking the court to do? If you have to confer with the other side, what's the form of the language you have to put in a certificate of conference? And when do you file it? What's the format you do? Some places are like, you just file a motion, and some places are you file a motion and a proposed order. Some places are you file a motion and a brief and a proposed order. And some are like, well, you do the motion and the brief and the proposed order, but if it's like short, then you can do a motion and a brief together. But you have to put that in the caption, the title of the document, motion and brief in support. So you get those. And then even on the question of when to file, most districts, you get your motion put together, get your supporting brief if you need one, get your proposed order, which most districts require, and you go file it, and the local rule says the other side has so long to respond to it. But in some districts, you do all of that, you prepare the package, and you don't file it with the court. You send it to the other side, and they prepare their entire response within the time allowed, and then they send it back to you, and you prepare your reply to their response within the time allowed. And at that point, with the complete package put together, that's when it goes on the docket and you file it with the court. So when the motion arrives at the court, it's complete. The court can pick it up, go through it, and make a decision, which has some interesting merits to it. Because when you're a federal law clerk and you're tracking the motions going through the office, we always used to have, basically there was a pile of, these are motions that have been filed that are awaiting a response. These are motions where we have the response, but we don't have the movement's reply to that response. And then you had the third stack of, these are the ones that are ready to go. And I need to get working on those, figure out where we're going. But you would be moving the paper along down the line, and the notion of the whole package comes in, saves time and effort within chambers of tracking motions, responses, and replies. It's just it's a very interesting approach to doing that.
Not all parties will file a reply, though, right? Is that optional?
That's optional.
Okay.
Yeah, just like filing a response is optional too. You can always be like, sounds like a good idea. Let the court do that. Most people file a reply. Ideally, the reply responds to the arguments made in the response. And to be effective, that's what it should do. There are replies you see that don't engage with a response. So you'll file a motion, you'll get a response. The response will say, deny the motion for reasons 1, 2, and 3. Then a reply will come in and will say, oh, just ignore what they said. Reread my motion and I win. And you're looking at it and you're like, but you don't actually substantively engage on 1, 2, and 3. So you see that. But you see the same thing in responses too at times. Plaintiff, or the defendant files a motion that says, hey, I'm entitled to this relief for reasons A, B, and C. And then a response gets filed and never grapples with the reasons A, B, and C. So there's a life that arguments have in these motions that you trace. That three are, A, B, and C is raised here in a motion. And where are they? Are they responded to in a response? And what is raised in the response? So good response, ideally, is going to say, I confront issues A, B, and C and respond as follows. Sometimes the sequence in which you want to address them is different. So sometimes the sequence that you lead with in a response is not the sequence that was defined by the movement. And then sometimes you go on as the filing the response, and you say, aside from A, B, and C, here are these independent reasons, D and E, that they never even mention in their motion why it should be denied. And then the reply is to rebut whatever they said about A, B, and C, and to respond to the new issues that they raised at that point. So,
but you want to address the points raised. Otherwise, it's just like missed opportunities.
Right.
Yeah.
Okay.
you want to address the points raised, and you want to address them with cases that actually
Yes.
talk about the law on those points.
Yes.
Yeah, it's different. Now, you recently had the opportunity to step off into the very different world of brief writing in the workers' compensation system. What was that like?
It was definitely different. Cases look different. They don't have the parties' names in them.
Okay.
I did find that kind of unique. But it also follows a similar structure. You want to have a very organized argument. You want to state your position, point to certain cases that support that position, and provide the rationale from the cases that you're citing to. Yeah.
Yeah.
So different, but also the same.
And why did you start doing that little project? Or
It was just a workers' compensation case that needed to be worked on.
Okay,
Yeah.
excellent. Well, that wraps up pretty much this episode. And so please join us next month for our next episode where we will talk more legal issues and get more perspective. Anything you guys want to add?
I think we covered a lot.
I think we covered a lot. Yes.
Yeah.
The only thing that I would like to add probably to that is that we have an eclipse coming up.
Oh, yeah.
And
April 8th?
something like that. I don't know. I don't know when it is, but it's coming up. And we will look to see. I wonder if there's any eclipse law.
Catch us next month.
That'll be next month. Yeah.
Well, yes. And then a reminder of our social medias, SMQ Law. Make sure to go follow us and keep track of what we post. Thank you so much.
Thanks.
Right.